But somebody who said they're watching is gonna get there. Oh. FYI. Thank you.
I don't think the mic was on.
Oh, so now the sound started. Okay. Thank you.
Do you want to say that real quick? All right. Good morning, everybody. Steve Wright, as Andrew said. So I'll go through a presentation this morning on the open meeting law. If you have questions along the way, please feel free to ask. Try to get your questions answered. If we can't answer those today, we'll get your contact information and get back to you. If you have any questions, we'll bring a microphone to you so that people on Zoom will be able to hear the questions and answers. And with that, we'll just get started here. Training objectives today, just a general understanding of the open meeting law, some common issues that come up, and then some resources that are available. The open meeting law, I think all the board members know that the crux of the open meeting law in Nevada is that things are done openly in the public and not behind closed doors. And if you remember that, you will generally stay out of trouble. Key points: actions taken openly. If you're making decisions as a board, quorum, or more than one member, you need to do that in the meeting. Deliberations, where it gets a little trickier, those have to be in the open also. This is a quote out of a Nevada Supreme Court case from many years ago, and just sets forth that standard that we talk about always with the open meeting law. Promote openness in government. The caveat to that is not all things implicate the open meeting law, right? You have to have a public issue that's before that board. A quorum must be present, which is a majority of the board members in most instances. And the open meeting law only prohibits collective deliberations, not individual deliberations, individual meetings, that sort of thing. Here's some definitions that come up frequently in the open meeting law. Deliberate. What does that mean? Just common definition. It means collectively to examine, weigh, and reflect upon the reasons for or against the action. Action means voting or a decision. Includes promises and commitments. And the action is when you take a vote in the open meeting. Any questions on deliberation? Quick checklist when you're reviewing for the open meeting law: is the body subject to the open meeting law? And for purposes of this training, everybody is subject to the open meeting law. All the boards in Lyon County typically are subject to the open meeting law. Is it a meeting? Is it agendized? Is the board getting together to discuss board business? Has it been properly noticed? Is the agenda appropriately posted where it needs to be? Does it include the right information? Is there an agenda? Is there going to be any deliberation? Is there provision for public comment? And is the board going to take action? And so when you're getting ready to set up a meeting and you're looking at your agenda items, you're going to go through this quick checklist. Public body, just background information. It's an administrative, legislative, advisory, or executive body of the local or state government. And that includes boards that advise or make recommendations to other boards that are supported by tax revenue. Is the body subject to the open meeting law? The statute sets forth those boards that are subject to it. And the ones that apply in Lyon County generally they're required by a statute. The board is formed by a statute: library board, board of county commissioners, planning commission, a number of others. Or it's created by ordinance of the local government, citizen advisory boards, or one example where that would apply. Committees come up from time to time. Committees are still public bodies. And a few years ago, the legislature tightened those requirements. And so if you're a committee of a board that's subject to the open meeting law, generally that committee is going to be subject to the open meeting law as well. And so we've seen a reduction in committees. It used to be that boards would designate committees to consider particular items and then report back to the board. But now that those are all subject to the open meeting law, it's much less frequent because of the burdens involved with the agendas and that sort of thing. And so generally speaking, it's resulted probably in a few more meetings of the bodies rather than having committees do those things. Here's the changes that were made in 2019. If you have two persons appointed by a public body, that's a committee. And if the committee is authorized to make recommendations to the public body, then it's going to be subject to the open meeting law as well. Any questions on committees? The idea, I think, generally with committees is you can't delegate the authority to make the decision without that being open and public. So you can't set up a committee, they solve all the issues, come back to the board, here's what you need to do. So that's why they've made some more restrictions on the committees. What is a meeting? Quorum is a big deal in the open meeting law. And this is where we see a lot of the problems with the open meeting laws and the alleged violations of the open meeting law. And the requirement for a meeting is that a quorum is present. And that's, as I mentioned, it's a majority of the board generally is a quorum. And there's some differences if the board's elected versus appointed. But generally speaking, for your purposes, is you want a majority of the board present to constitute a quorum. If you are on an elected board, the requirement is that a majority of the elected board must vote to approve or deny an action. So it does generally require more members to take action on an elected body. It's still a requirement that a quorum be present for the open meeting law to apply. Some audio-visual requirements. The public body must make reasonable efforts to ensure facilities are large enough to accommodate anticipated attendance. And I know this comes up from time to time. It's not frequent, but now with more and more people in Lyon County, it's becoming more frequent. But it is something you need to be aware of, that if you're holding a meeting and you think there are going to be way more people that can fit in that meeting room, you may want to reach out to Martha or Andrew just to have a discussion about that if something needs to change on that meeting. Because it could be a problem if half the people are standing outside and can't hear what's going on at the meeting. We try to make arrangements to get around that. That happens at the county commission, that the room is full and there's a lot of people outside. Doesn't mean you can't hold the meeting, but sometimes special arrangements are made to try to accommodate that with either speakers outside or allowing some other means for people to participate in the meeting. Serial briefings, and this is kind of an antiquated term now, but it's very common with all the electronics and social media and email that we use these days. Serial briefings are where you are meeting individually with board members to discuss an issue. So Wynn may want to meet with board members on an issue that's coming up at the library board. That is not a violation per se, but where you get in trouble is if there's any communication between board members, which would happen if, for instance, Wynn met with each board member and then told, as she went down the line with the board members, told, for instance, Patty what Nora had told her about the same issue. And then you get into an issue where perhaps there's deliberation going on between board members, not intentionally, but it can be interpreted that way. So you need to be cautious. If you're meeting with your other board members, you're on an advisory board and, hey, there's a contentious issue, I'm going to call another board member. You call them up and you talk to them. And then that board member calls another board member, hey, I just talked to the chair and this is going on. Another call, pretty soon you're in violation of the open meeting law, right? You're discussing an item outside the agenda. So this is really kind of an important issue when you're communicating with your fellow board members or you're communicating with staff who is communicating with board members and gathering information as sort of a body. This is a little more about that, the walking quorum, where you go from one board member to the other. And this just summarizes what I talked about a little bit. Any questions on that? And we'll get into it just a little bit more. This is the case that kind of set up this requirement. It's an old case now, but it involved the Board of Regents. And what had happened was Nancy Price had made some comments to the press criticizing certain decisions of the board. And I know as board members, each of you from time to time gets criticism from the community or whatever. So this is a very tempting thing. It's like, we need to respond to this. It's not accurate, or we need to clear the air or whatever. And so what happened is some other regents made their concerns known to the chair. The chair met with the public information officer and asked that she draft a response to Price's comments. See some problems with that coming up? A response was prepared. It was sent to everybody but the one regent that made the comments, and said it would be published the next day. And if anybody had any other comments, some board members responded to the request, and nothing ever issued. There was never a statement or anything from the chair or from the board as a whole. And the Attorney General filed a complaint. And what do you think? Is that a violation of the open meeting law? Yeah. Yeah. Even though there was nothing final determined, just the fact that they made all the decisions outside the meeting on a board issue, it is a violation. And so that just gives you an idea, kind of background, how you have to be careful. Where we see this a lot, there is one exception that doesn't come up for many boards, but that's if you're in an attorney-client communication. Some of those are not subject to the open meeting law. And so if that's a situation, if you're called by the attorney, again, the attorney has to be involved in that communication though. So if you talk to the attorney and there's a couple board members present or whatever, and then that board member calls another board member and the attorney is not present, that's not going to be subject to this same protection. So be careful about that. The big concern that I know that Andrew, Martha, and I see from time to time is emails, because it's an email society. I know that's how people communicate now. And it's not always the best way to communicate, but it's the reality, right? And so what we see a lot is, like, you have a hot issue in wherever, Stagecoach, and so somebody starts emailing the board members, all of the board members, and the board get those emails, and the temptation, just like with the Board of Regents, is you want to respond. Maybe there's misinformation, maybe they don't understand, maybe they need to have more information. And so you just send out an email, hey, I think you're wrong. This is what's really going on. I'd be happy to meet with you. And all the other board members are on that email. And another board member responds in, same thing, maybe, something like that. Pretty soon it appears like there is discussion on that item among the board members. And so that's where I think you really have to be careful. And so we always caution, if you're on a group email, don't reply all. Don't reply with all your other board members on there. If you want to respond to it as an individual board member, and sometimes you have to, and you should, right? As a board member, you have certain obligations to the public, and you want to. We just encourage you to be very cautious if you're going to reply all and end up in a situation that was never intended, but suddenly you're in violation of the open meeting law. Any questions on emails? Yes, let me get the.
The bonus part that can go.
So if you're there's an issue that was on your agenda that members of the community are forming a separate meeting to discuss outside of the board meeting, and you're invited to that meeting. Is it not as a board member, just to go as a resident? Is that appropriate to go?
Did everybody hear the question? Yeah, so yeah, there's a community meeting separate from the board meeting. One of the board members gets invited to go. Is it appropriate to go? Maybe, right? The typical attorney answer. You have to evaluate whether or not it's going to benefit you as a board member. A lot of times it's not fair to your other board members for one person to say, because you don't want a quorum going there, because then you may have a problem. Even though it's open to the public, it's not a formal meeting. If you have a majority of the boards there, you could have a problem. Want to avoid that, number one. Number two, you want to evaluate. There may be times where it is appropriate for you to go to that meeting, but is it fair to your other board members? What do you want to do if you're going to go there and participate and represent yourself in a board member and say, this is what's going on the board? Usually that is not appropriate, that kind of thing should happen in the board meeting. And so I think it's just a case by case basis, but you do want to be careful acting as a board member at a community meeting where there may be opposition to an item that's coming up on the agenda. Does that answer your question? I don't. Yeah.
So it would be acting as a member of the public, not a board member, not attending in an official capacity, attending as a resident.
Yeah.
Would there be any difference with that?
Yeah. So the question is, if I'm going as a citizen, not a board member, is there a difference? There might be a difference, but unfortunately, when you're a board member, you're always a board member. And there's no way to really make that distinction. And so that's where I think that you just need to be cautious. There are some meetings you should attend that items that will come to your board for sure. There are community meetings where you want to participate. Maybe Andrew's doing a presentation or Gavin, or maybe there's another agency, a federal agency or state agency or whatever, making a presentation. Yeah, it's appropriate to go to those meetings because number one, you want to be informed. You have to be informed as a board member. But what you don't want to do is go there with the impression that I'm speaking for the board. I'm going to give you information on where the board stands, that kind of thing. That's where I think you could run afoul. So I'm not saying don't go to those meetings. I'm just saying evaluate them on a case by case basis. Is it going to help you as a board member? Is it going to help the community? And is it appropriate for you to be there?
Can there be a situation where it was an agendized item? The board knew this meeting was coming. They made a decision of what the board statement would be, and they sent a representative. Can that happen?
Yeah, did everybody hear that question? Can the board say there's a community meeting coming up on this mine that's going in Silver Springs? You put it on the advisory board agenda to make a recommendation for somebody to go to that meeting and make a statement on behalf of the board. Yes, you can do that. If that's agendized public meeting, the board decides that they want to do that. They want to send a representative on behalf of the board. I don't see any problem with that.
One thing I'd like to add too, going back to Amanda's question, there's a big difference between going to something like that and listening versus going and speaking your opinion on something like that. Because it could be, especially if it's something that's going to be coming before your board, it could be perceived as you predetermining an outcome before hearing the presentation or before hearing all of that. So you have to be really careful about that kind of thing.
Great questions, though, in difficult situations for board members, I know, because you want to be in those meetings, you are part of the community, and all that's important. You just need to be careful. Yeah,
Hey,
Charles.
Steve, when you go to meetings like that, is it not a good practice to clearly state that you're there as an individual and not representing any board, and just listen?
Yeah, always a good practice to say that if you're given the opportunity. If you're just going to stand there and listen, I don't know that you have to make a special point of it, but yeah, if you have the opportunity to say you're just there as an individual, that's always good for the public and good for the board. Any other questions on that? All right, yeah, those are good questions, difficult answers. I know they come up frequently for the board members. Texts are still a pretty big issue in Lyon County and probably all over Nevada. Because we don't have a great way to track text. We try to track emails to a certain extent. We've provided emails for all of the advisory boards. Lots of the county boards now have county emails. We encourage you to use those because then we can track what's going on. We're able to see all the different emails. So that's a little bit easier with some of the emails and some of the boards. Text are a lot more difficult because we don't provide cell phones to board members or any of that stuff. But just remember the same rules apply on text as they do on emails. So again, you can end up on a group text that you're not even sure what's going on. If you don't know what's going on, probably better not to respond and as a board member. Let's see. The other thing comes up, use of phones and computers at meetings. The DA's recommendation is don't do it. I know you have computers for your agenda and things like that. Sure, that makes total sense, right? That you're using that to conduct your meeting. What the concern is that you're communicating possibly with the public or other board members during the meeting. That's not deliberation in the open or public. Can be very burdensome for you if somebody raises that complaint. You got to turn over your cell phone, even if it's your private cell phone. You got to turn over emails, you got to turn over your computer, whatever. You don't want to get in that situation. Same with phones, just bad practice to be using the phone. I'm bad about that too, but try not to. If you're sitting in a board meeting, try not to be on your phone or using your phone because you may be texting your family or whatever, perfectly legit stuff, but it gives the impression, especially if it's a contested item, that you're doing something you shouldn't be doing. As a board member, maybe communicating about that item.
Steve.
Yeah,
Yeah.
hold on just.
Okay, our secretary likes. Yeah, it's on, I think. Our secretary likes recording the minutes on her computer as the meeting's going on. Is that okay to do?
Yeah, the question is, can you record on your computer? Certainly. That's a good way to record it. Now, it used to be it would be an audio record, but I think it's fine to record it on the computer. It is required to be recorded, and that's one mechanism we can use. Okay. These are really antiquated kind of things now because of the use of Zoom in meetings, but you can hold meetings if they're properly noticed and the public's able to participate by these other means. The Zoom meetings, and those are generally authorized. Not all the boards have that capability right now, and I'm not sure that they will anytime soon, but it is allowed to have remote meetings, appearance by Zoom. The requirements are that you have proper notice, which includes the right Zoom link. So be careful when you're making your agendas to verify that. We've had a number of issues where, you have the prior agenda and that Zoom link's, 100 characters long or whatever it is. It can be. So you look at it, you think it's the same one. It's not the right one. Something gets mixed up in that. And the result is you'll have to cancel that meeting and reschedule it. So just be careful about the links that you put on. And with the Zoom, your system has to be working. So there's two-way communication. They can hear you and they can participate. And generally the county, it's not required by the statute, but the county does require still a physical location for the meetings. So all the boards that do Zoom, it's still required by county policy that there be a physical location for the meeting. Just some general information, including the slide presentation on what needs to happen. I think everybody's so used to Zoom meetings that this is kind of old hat. But does anybody have any question on the Zoom meetings? Another big issue that we wrestle with, we don't have great answers yet for, is social media and communication through that. Because there is a lot of that. It's very helpful for the board. How do you use that in the meeting? Can you use it? How do you track it? How do you monitor it? So the same rules apply, and we'll get into that in just a few minutes on what, when you're preparing the backup for your agenda, what's going to go in there when you're preparing the minutes, what are you going to reference, those kinds of things. And I think that's what you need to be careful about with Facebook, Twitter, any other social media that you might be using as a board member. Again, just remember that can be part of your deliberation. Again, Facebook, I don't use Facebook a lot, but I believe you put it out publicly and a lot of people can chime in on it. And especially on these contentious issues, there's a lot of feedback back and forth. And if you look historically, you may see that, suddenly you find that several of your colleagues have commented on Facebook posts. Could cause a problem going forward if it's an item that's coming before the board. So just be cautious with those kinds of things too. Any questions on social media? Internet yeah, go ahead. Hold on just a second.
The meeting, Facebook, social media is okay. To actually post the notice of the meeting on social media, is that okay?
Yeah, the question, can you post the agenda on social media? Yes, you can. That does not satisfy the posting requirements. That's an additional just notice to the public. I don't see any issue with that. Any other questions? Does anybody do that already? Yeah, so Amanda, and it works pretty well probably. It's a common communication. These different communities have groups and stuff, so it's a good way for them to be up to date on what's going on and there's a meeting coming up. So I'm sure it's effective in that way. The other thing, internet research, we all do that, just the nature of today. The issue on some of these items that come before the board, some of that can be, if you're relying on a lot of information that is not before the board, you need to be careful about that. And, there's ways you can address that, but I think the general rule is, yeah, you have to do your homework, but you also should rely on staff and the information that's provided by the applicant or what's going on in that particular issue, right? It's not fair to somebody who has an item, for instance, a planning item coming to the Stagecoach Advisory Board, for you to do hours of research, accumulate everything and make your own decision before they even come into you and not consider what the staff has put together and what the applicants put together. That could result in a violation of their due process. You're using information that was not provided to them. And so we urge caution, especially on planning, private property issues, those kinds of things. We urge caution that you don't do a lot of and consider a lot of information that isn't available publicly. Any questions on that? Some exemptions from the open meeting law trainings like this. You can have your entire board here. You can go to the training. Social gatherings, not subject to the open meeting law. So community meetings, things like that, where it's not an agenda item or anything. You don't have to worry about everybody being at those. You go to other public meetings, things like that. You're allowed to do that stuff as board members. I don't think we don't really see too many issues of those, but I know sometimes there's questions come up. Board members want to go to an event or they want to go to another meeting that's important to what they're doing. There's no problem with doing that. Yeah, posting the agenda. Again, usually the boards have somebody that kind of assists with that. The general rules are 3 working days prior to the meeting. Does not count the day of the meeting. Sometimes people get in trouble with that if you have a night meeting. So if your meeting's on Wednesday night, it has to be posted no later than Friday at 9, if there's no holidays, to count those 3 full days before the meeting. You have to provide the agenda to anybody that's requested it. Usually that's done via email. And that once they make that request, it's a continuing request for 6 months. Remember holidays, sometimes those create issues, especially the Monday holidays. You forget about that, end up that your notice is a day late, and so you have to reschedule the meeting. The the requirements for the notice documents, the date and time of posting the meeting, the address of where the meeting was posted, and the signature and title of the person that posted it. And that's usually just maintained by the secretary on the cabs and stuff. That information is usually provided to Martha. The agendas, creation of the agendas. This is another issue that comes up quite frequently. And the general principle is you want the public to know what's going on the agenda. What are you going to be discussing? And so be specific on your agenda. Don't be too specific, because if you want to be able to discuss the item in full. Make sure the board's authorized to take that action. Most of the boards have sort of a limited area of coverage, what they're doing. So, you know, if you're Dayton Advisory Board and you want to have an agenda item on a Silver Springs matter, you're going to have to somehow link why that falls under the Dayton Valley Advisory Board. It does come up from time to time, but make sure we don't often think about that. Is this something that our board does? If it's not, don't put it on the agenda. That would be the preference. Make the agenda language match what the board is going to be doing. And we'll talk about that a little more. That comes up especially in planning items. Add more in the agenda. If you have a question, are we going to discuss this too? Add it in. You can always discuss less. You can never discuss more. So you don't want to have to reschedule an item because you left off a small piece that you wanted to discuss. Planning example here. You can get help on the planning items, but usually the planning items are pretty specific. They have what the application is, what properties involved, and what they are requesting. And so we ask that you try to include all that if you are considering planning issues, land use issues. Here's an example from several years ago. Another, like a contract item, if a contract or something's coming before the board, you know, you generally want the parties to the contract, the term of the contract, and what the subject matter of the contract is. If your entity, the library, or whoever is paying money for it, you like to include the contract amount if that's available. And that way the public has a good idea of what's going on. A lot of times it's cleanest for the minutes and for the board and the public if you draft your agenda item such that if everything goes like you want it to and you want to approve that agenda item, your motion really matches the agenda language. And then it's easy to track for the board members. It's easy to track for the public. And it just makes everything a little bit cleaner on that. Does that make sense to everybody? And I think we're seeing that a lot now on the boards. It's really, everybody's been doing a good job on that. We try to stick to the agenda and then make it easy for the board members to make the motion if it's approval or denial. Here's just an example. I think this is from the Incline Village GID. But there's an agenda that said District Board Policy 3.01, conduct meetings of the Board of Trustees, specific section 11, officers of the board. And they approved a reorganization of officers under that agenda item. I mean, when you read that agenda item, it's like, what are they talking about? Right. Right. The problem is, though, a lot of us work with our boards all the time, right? We have policies, procedures. We know the CAB policies. We know the library policies. We know the planning department policies. So if I know what policy 3.01 is, I look at that and say, that's fine. I know that's the policy that deals with directors or whatever it is. But the public does not. So that's why you get in trouble with the open meeting law. Especially if you're doing like policy things, you're referencing, county code, things like that. Always put in the language because the general public's not going to know what most of that stuff is. And so that's where we see this come up sometimes is when you're discussing things that are maybe more internal to the county code, Lyon County code changes, policy recommendations, those sorts of things. Just be careful how you do that. The agenda has to stand on its own. We see this from time to time too. Oftentimes you have a good a good package, like from the planning department or from the applicant, they want to come in and talk to you about a project they proposed in your community. And they put together a big packet of information, they give it to you, and your secretary attaches it to the agenda, has all the details you would want. But your agenda is too vague. And people say, well, all the information's in the backup. No, the agenda has to stand on its own. You can't resurrect the agenda by saying, oh, we had all that information in the backup. All that backup's helpful, but it does not get around having the language on the agenda. Yeah, the other things on the agenda, the time, place, location of the meeting, a list of the location where the notice has been posted. It used to be you had to post it at least 3 locations. That's no longer required, but a lot of boards still do that. So if you are still doing that, we encourage that you put it on the agenda. Your action items have to be indicated. Everybody's doing that. It has to say for possible action if you're going to take action. There's some other standard language that's included on all the agendas, and Martha can help you if you have questions on that. There's some stuff you'll see in our agendas that maybe doesn't make sense, but it's usually required by a federal grant or some other provision. So we are careful about trying to keep that information in the agendas, even though it may not be directly related to your board activity. You'll see some stuff and think, why is that on there? We usually have a reason we want that included. The agenda in Lyon County, we always do it the same way, pretty much. Must have 2 public comment periods, one at the beginning, one at the end. And who you contact to get the agenda and supporting materials. So that's on everybody's agenda. You want to make sure that's accurate and updated. Sometimes you have a change in board members, you have a change in personnel, whatever. You just want to check that from time to time, make sure it's accurate. We talked about the 4 possible action. We usually recommend that you have a lead-in sentence on your agendas, and almost all do, that you take items, you can take items out of order. You can combine items or remove items at any time. And if you have any public comment restrictions, those need to be included on the agenda. We'll talk a little bit more about that, but most of the boards now have like a 5-minute public comment limit, something like that. And there's ways you can work with that, but it's often a good idea to have those limits on your agenda in case an item with a lot of public interest comes forward. You have a lot of public comment, you can use a lot of time up pretty quick if there's no limit on how long somebody can speak. Some of the problem areas that we see on the agendas, where you may or may not be taking action, like workshops. A lot of the boards like to have workshops. We're going to discuss things and figure out some options and just get a general discussion, get input from the public. Maybe you have somebody, a consultant or somebody working with you, providing information, planning department, whatever. And so you have a workshop, get through everything. One of the issues we have, though, a lot of times you're there to take action as a board, right? That's what your purpose is. You want to make recommendations, make decisions, and whatever it is, help get those matters resolved. And so in a workshop, a lot of times we see a workshop comes up and it's not for possible action. So you get to the end of the workshop, what does the board do if it's not for possible action? Nothing. And that can be a problem because a lot of times when the board has a workshop, they expect to take action at the end. That action is probably pretty generic, like we're going to recommend to staff that they do this, or we're going to recommend that this come back to the board at the next meeting for formal action on this. And you want to be able to do those things. If your agenda doesn't say for possible action, you can't. And so that's why, especially on workshops, we're careful. You will see some at the county board of commissioners where there's not for possible action, but 9 out of 10 times we're going to allow some action. Because a lot of times the board of county commissioners may want to send it back to staff, bring back this to us, do whatever. It's not what we would view as maybe a decision type action, but it is decision. But so if you want that option, make sure you have for possible action. Reports, generally reports are not possible action. That's, we recommend that they not be possible action because you don't know what that report's going to include on. The workshop agenda items are usually detailed enough to know what's going to be discussed and what's going to happen. On reports, that's usually not the case. Report from the Lyon County Sheriff, report from Planning Department, whatever. You don't know what they're going to say. So you don't want to put for possible action. You don't want to take action because you're going to run into a problem with that clear and concise agenda issue. Presentations for possible action, same thing generally. So workshops, think about possible action. Present reports, think about no possible action. Presentations, look at what you have. If you have the presentation ahead of time, it's within your purview and you think you want to take some action based on that presentation, then make sure you have the for possible action. Updates, again, they're generic, usually not recommended for action. Future agenda items, this is a big thing that's come up and we do recommend for possible action on this because people have a chance to comment on it. And it's often the only chance the board has to discuss those future agenda items is at the meetings. So we do encourage you to do that. Remember that deliberation to put an item on the agenda is deliberation by the board. So you can get into an open meeting law if you're doing that outside the meetings. Some of the board, we do see that on a lot of the board agendas now, future agenda items. Any questions on those? The kind of things that come up frequently and whether you should have for possible action. Yeah.
This may be covered later, I'm not sure, but on the agenda, sometimes I see amended agendas. And to what extent can an agenda be amended? Like if there's a planning item that you didn't get on there, I'm guessing it couldn't go on, but to what extent can an agenda be amended? And then I also have a question on the future agenda items. Is that, we kind of use it on our board to see if members of the community are requesting a future agenda item. Are we using that incorrectly?
So, two questions. I'll take the last question was, Stagecoach Advisory Board is using the future agenda items to allow the public to request agenda items. Is that okay? Yes, that's okay. Caveat is the board controls the agenda. And so and I think Stagecoach handles this appropriately. So not everything the public wants on the agenda gets on the agenda. And as long as you're making that clear to everybody, that's okay, right? It's not, the public does not have a right to put an item on the agenda. The board makes that decision, or the chair sometimes makes that decision based on the checklist we looked at. Is it within your purview? Can the board take action? Does the board need to take action? There's a lot of items of public interest in our communities. Not all those belong on the agenda. So you need to be that gatekeeper. Does that answer your question on that? And the other thing, we like to use the future agenda items for board members to recommend agenda items too. I think that's a good chance to do that in the public, and the public can certainly weigh in on this. And then the other question was,
The extent we can amend it.
yeah, amended agenda. Sorry about that. Yeah, the amended agenda. The agenda cannot be amended. That is a pet peeve we all have with our system at Granicus, because if you look, the agenda is posted, and then 2 days later you get an amended agenda. Just to be clear, the agenda is never amended. Once it's posted, it's done. If you want to change it substantively, you have to re-notice the meeting. Okay, yeah, the 3 days you can't go in and add an item once you post the agenda. All the items you're going to consider are part of that 3-day notice. What you see on the county system with amendments is usually additional backup is added, but there's no change to the agenda substance. There's no change to the actual agenda items. If you're going to do that, that item that you want to change either gets pulled at the meeting and moved to another meeting, or the whole meeting gets rescheduled. Yeah, Jim.
So say an agenda is posted 5 days before the meeting, and 4 days before the meeting, some additional information comes up and you'd want to amend that agenda still greater than the 3-day notice, is it possible to amend it as long as there's still 3 days notice period?
Question is, can you amend it if you still have time for notice? Absolutely. If you post the agenda a week before and you said, oh, we want to add this item, you still have the 3 days, absolutely, you can amend the agenda. Yeah. And we certainly, if you want to post your agenda early, that's a good idea, because if somebody notifies you of a problem, you can fix it. And so, yeah, we don't, often the agendas, just because of the way the system works, are posted right close to the end, because by the time you get comments and everything together, it tends to be close to that deadline. But yeah, if you post it early and you want to add something, you can certainly amend the agenda in that instance. I'm only saying once you've hit that posting deadline, no amendments. And I know if you do look at the county system with all the boards, you see these amended agendas. That's what they're called in the system. They're not amended typically. It's usually something is added as backup. Somebody sends in an email, whatever else. And so that's why it's listed as amended. Everybody understand that? Any more questions? I know that may be a little confusing. Okay. Some basic public meeting rules, and this is really for protection of the board, but it also helps to just keep the meetings orderly and more productive. So stick to the agenda. That's pretty straightforward. You just want to keep on the agenda items and just work through the agenda. Chair and members of the board, try to keep the other board members from drifting into other subjects. It's easy to do when you get in discussions on certain items to talk about other things. Always try to direct the other members back to what the agenda item is. And then all comments and presentations are made through the chair. Especially on a contested item, you really want people to work through the chair. You don't want people making comments to other board members, talking to the public, doing whatever else. The chair really should try to keep control of that meeting. Everything is run through the chair. Administrative action. This is the reason we bring this up. It comes up from time to time, and it does limit what boards can do. Administrative action is against the person, and it requires special notice. Kind of like a personnel action. And so if you're going to take administrative action, you have to provide special notice to that person, and either 5 days personal notice or 21 days certified mail notice. And the issue where we get concerned about this from time to time is more often situations involving like an individual's personal characteristics or qualifications. And where we see, I think, problems with it is like with private property issues, and especially code enforcement issues. Each of our communities has code enforcement issues that are very important to the public. And a lot of times there are certain properties that come to people's attention, and they want on the agenda, we want to talk about property X because it's an eyesore, or they're conducting a business without a license, or they're doing something that's serious for the community. But you have to remember, you can't just put that on the agenda without noticing that person. You're going to discuss them and arguably their character. And you may take an action that affects their property, and they're entitled to notice more than just open meeting law notice if that's going to happen. We don't encourage those kinds of things for most boards because it can get complicated and it's generally not productive, but it does come up from time to time. And if that's going to happen, we do recommend you reach out to Martha and Andrew and just let them know. Sometimes the way we work that is the code enforcement will get involved. The planning department will get involved, and we'll try to fashion a way to do it where you don't run afoul of the open meeting law, and you don't put that property owner or property owners in an awkward position without giving them a chance to weigh in before anything's done. Any question on administrative action? Just something to be aware of. My experience, I don't know, Andrew, if you have different, but it's usually on planning, code enforcement, things like that, where you want to discuss something that's going on in your community. Yeah, animal control. Public participation. This is a big issue, comes up from time to time. We do it the same way in the county, and we encourage all the boards to do it the same way. Not all the boards do, but most of the counties under the umbrella of Martha and the county manager's office do. And that is 2 public comment periods, one at the beginning of the agenda and one at the end of the agenda. And then also allowing public comment for each agenda item before action is taken. So that's how we recommend you do it. The law only requires the 2, one at the beginning, one at the end. But we just find it's better for the board, more beneficial for the board and public to allow public comment on each agenda item. Some general requirements. If the person requests that the comments be included in the minutes, you have to include them in the minutes. If a person requests that you read their comments at the meeting, you do not have to read the comments at the meeting. Some people send in an email, please read my email. It's a 3-page email or whatever. You don't have to do that. You are required, though, if they ask to be included in the minutes, that you include those in the minutes. They can send in public comments by email or messages. And the public participation, one of the important things I think for boards, the recommendation is that public participation is a time for public to come forward and make their comments. It is not generally time for question and answer. And you get into problems, especially if it's not an agenda item, getting into question and answers with public, because you are suddenly deliberating in a matter of minutes on a decision that may become before you in a meeting or two. And so you're suddenly in violation of the open meeting law. We always recommend that you have a reasonable restriction of time on the public comments, and the board just listens. If there's an issue that comes up at the end of the meeting or whatever, you can direct staff or to look into something or whatever, but you don't want to get into a discussion on items, number one, that aren't on the agenda, and you don't want to give the public the impression that they get to sort of run the meeting with questions and answers. They can ask questions during public participation for sure. They may get answered during the process, but they're not required to be answered. And so just that's the recommended course of action. Any questions on public participation? Because I know that's a big deal. Amanda?
So you had said that even if somebody asks for a comment to be read, that you don't have to read it. If you get a public comment prior to the meeting, how would you get the information about what was in that public comment to the remainder of the board? Would it be emailed to them? They don't always check their email. Would it be printed up? Or if you got it like right before the meeting, how does that information get disseminated to the rest of the board?
Yeah, question, common occurrence. You get public comment via email right before the meeting or even a day or two before the meeting. How best to handle that? And our recommendation is the open meeting law, we'll get into this, I think, in a minute. It requires that if you provide information to the board members, it has to be provided to the public at the same time. And so generally, if you're right up against the meeting a day or two away, we recommend that you have copies available. You provide those at the meeting and you provide those to the board members at the meeting to avoid any issue of you giving information to the board members that is not provided to the public at the same time. That can be burdensome for some of the boards, advisory boards and stuff like that, to get the copies and do all that kind of thing. But that's the recommended course, because if you send it to the board members and not the public, that's a violation of the open meeting law. And any other questions on that?
So it's right before the meeting?
Yeah, if it's right before the meeting, I think the best option is you provide it to the board members and you try to make a copy available to the public. You only have one copy. I think you can show it to the board members and offer it to the public. Yeah, there's not a real great fix for that. And maybe you have a deadline where, you know, once the meeting starts or there's no more public participation to be submitted in writing or email. Should be a cutoff for that.
We generally have a cutoff. That's pretty good.
So that just some general rules that everybody I think handles well, but person can request copy of the agenda and it can be sent electronically. It's a continuing request. Some of the things we've already talked about. You can't amend the agenda after the deadline. You can add additional backup after the deadline. Supporting materials. If somebody requests you provide a copy of those, you must provide them at the time the agenda is posted. And this is what I just talked about with Amanda. Any materials provided at a later time have to go to the public or the people requesting it and the board members at the same time. You can't provide it to the board members and then wait till the meeting and provide it to the people that have requested it. Okay. The materials is not a continuing request. That doesn't mean the board should not consider it a continuing request. Sometimes it's easier just, and a lot of times now with the way the agenda is, it all gets emailed out together, backup and agenda. But remember, in the open meeting law statutes, the backup material is treated differently than the agenda. The agenda is a continuing request. The backup is not. You can require somebody to request it each time. With posting on the state and county website, that's not really an issue. Usually they just get directed to that and look at it that way. You have to have one copy of your materials for the meeting at the meeting location. You can provide an electronic copy. I've never figured out how this works logistically, but for most of the boards, it's not a great option because it's not possible really for people to view that at the meeting. Minutes. We have some recommendations for how you prepare the minutes. Usually the best practice is to state the agenda item in the minutes, the substance of the matter, the motion and the second and the vote. And it is, if it's a split vote or whatever, it is beneficial sometimes to list who voted which way. Public comment, if the person requests it be included, has to be included. Otherwise does not have to be included in the minutes. Any other board member or any other material a board member asked to be included in the minutes should be included. And you'll see pretty wide variation on the minutes. But I do think it's important to try to get a little bit of the substance of what was discussed. If you have 50 people making public comments and stuff, your minutes are not going to include all of those. But you do want substance so that you can review the minutes. It's beneficial for the board. If you're looking at an item, want to see what happened previously to be able to go back and just see a little bit of a summary of what went on. The minutes have to be available within 30 days after the meeting. A lot of questions come up. Well, we don't have another meeting for 45 days. How can we make the minutes available? You make a draft of the minutes available, and then when they're approved at a later meeting, those are swapped in for the draft. But we want to have the minutes available within 30 days. And some of the requirements. The meetings have to be recorded too. I know Tom talked about using the computer to record those, and I believe Martha will provide you with a recording device if you don't have one. But I think everybody's set up to do that, but don't forget that the meetings do have to be recorded. And a lot of times if they're on Zoom or whatever, that's a recording too. Verbatim minutes are not required under the open meeting law. What I talked about, a violation of the open meeting law can occur if there's no discussion at all about sort of what was discussed at the meeting. And the minutes too, it doesn't matter if action's taken or not, the minutes still need to include the discussion on that item. Public comment. Again, you can't restrict what a person says generally. I mean, there's certain things obviously people can't say. But as a general rule, they can public comment, they can say whatever they want. They can't obviously threaten board members, do things like that. And you can't ask them to stop if they're doing other inappropriate conduct. But other than that, there's very few limitations on what a person can do. And so you have to be cautious about that. And my recommendation is always that you let the person make the public comments. A lot of times people come up at the beginning of a meeting, there's an item on the agenda they want to talk about. And so they come up and they start making a public comment about that. The chair can certainly say that's coming up later on the meeting. If you want to wait until that item, that would be our preference. But if the person doesn't want to wait, they can make that comment at that time. There's nothing that precludes that. So if you're the chair, you need to be careful about saying we don't want to hear that. You can make it at the time of the item. You can't do that. They can make a comment on an item at the agenda at the beginning of the meeting. They can make a comment on an item on the agenda at the end of the meeting. We prefer they make it during the item when you give them a chance, but they don't have to. Yeah.
Can they comment both times?
That's it. Sarah's question is, can they comment both times? That depends on your restrictions on public comment. And a lot of times you're limited to, especially if it's on an item, to one public comment. And if you have a time limit, you're limited to that time limit. And so we ask that you follow those limits and you be strict about that. So the person can't come up at the beginning, make comments about the item. They're advised, we're going to discuss that later. I want to make my comments now. They make them, and then they don't get to come up again and make it during the item. Okay. That answers your question?
Yeah.
Yeah. Any other questions on public comment? On the time limits, I know most of the chairs have dealt with this issue. You want to have, we recommend limits because we do have items that come up from time to time that just require a bunch of public comment. And we want to allow as many people to speak as possible, but we don't want the board to be there for hours on end, hearing the same thing over and over. And so there's nothing wrong with the chair saying, we want to hear your public comments. We expect a lot of comments, but if you're just going to repeat what the person in front of you said, or what two people, you can just say that and that'll be noted in the record and we'll consider that. So that's fine to say that. That's not limiting public comment. They can come up and repeat exactly what the person says. You can't stop them from doing that, but you can encourage people to, you know, if they're going to say the same thing, they can reference the prior comments or whatever to try to streamline the meetings. The chairperson has discretion to allow more time or limit a person's time depending on what's going on. You have to be careful if you're going to limit somebody, because you better limit everybody else. So you need to be cautious about that. But we do allow extensions of time. And I know sometimes it's difficult to make that distinction, but a person's going through their public comments, they have a little more to say, they want to do that. There's nothing wrong with the chair allowing the person to finish the comments. That's not a violation of the open meeting law. Doesn't create a problem. You need to be careful though, that then everybody doesn't come in and say, I get an additional 30 seconds or whatever. They don't. Just because you let somebody finish doesn't mean everybody gets an additional minute or whatever. It's the chair's discretion. We ask that you kind of exercise it reasonably, but be fair to the public. And that seems to be the best practice with respect to that. The other thing that comes up, and we struggle with this a little bit at the Planning Commission and County Commission, is people involved like in a project, or people that are personally involved in an agenda item. Maybe they're with the group that's doing an agreement or a grant or whatever, and they end up coming up, and are they public participation, or are they the applicant? Do they get more time? They're not subject to that limitation. The recommendation usually is if they are part of the application or whatever that's coming before the board, they are not subject to those same limits. And so we would encourage you not to put those same limits on those kinds of things. You can certainly limit that, though. You don't have to say you can come up and speak as long as you want. But we do try to give the person that is trying to persuade the board to move forward with their item or whatever a little different consideration than the time limits that may apply to the public. Any questions on that? How to avoid violation? I think just pretty self-explanatory. Just make sure that if you're working with board members, discussing things, just make sure you're careful and you don't run afoul of trying to do things outside the meeting. This comes up from time to time, and a number of years ago, we had a board that was constantly getting in trouble with the Attorney General's office at the time. And the response when we would talk to the board, whether it was the county manager's office or the DA's office or whatever, we're just volunteers. We don't understand all the rules and we can't do it. That does not work with the Attorney General's office. Whether you're a volunteer board with no experience or you're an elected county commissioner, the rules are the same. That can be very difficult. You know, I know most the boards don't have attorneys at their meeting. They don't have people there to tell them what to do. So you have to make decisions on the fly. But the rules are the same, no matter if you're on the Board of Regents or you're on the Silver Springs GID. The rules are the same. So just remember that just because your board is smaller or whatever, the rules are the same. Corrective action. This comes up from time to time during a meeting. You find out that there's been a violation, or after the meeting, you find out there's been a violation of the meeting. We encourage you to reach out to Martha, or if you're in the meeting, you can fix it in the meeting. Recall that agenda item, put the violation on the record, and allow comment, and then move forward. Okay. How that happens, you know, if you take a break and some board members are discussing an item on the agenda, which you shouldn't be doing, but if something like that happened, you would go back into the meeting and say, hey, we discussed it. We didn't realize that somebody was going to talk to somebody else, and they did. So this is a violation. We just want to put it on the record. Any public comments? And then if you need to change the action or whatever, you can do whatever. If you find out after the meeting that happened, you can re-agendize that item for the next meeting. And the agenda is a little bit different, but it's agendized as a violation of the open meeting law. And the advantage of that is you can fix that problem before it gets to a complaint or before it voids your action. Right? You want your action to stick. And so the best way to do that, if you know of a violation, get it on the next agenda. Just a little bit more on this is an example, I think, in Douglas County where the Planning Commission corrected an issue during the meeting. What happens if a violation occurs? That the biggest thing is the action that was taken is void, so it can be messy for the board, and you have to redo everything. It can be a crime. There can be fines, sanctions. Fine of up to $500. You also have to agendize violations. The boards, we don't want to do that. We don't want to have to put on the agenda that we violated the open meeting law. And here's the opinion from the Attorney General's office for all to see. So we just try to be careful and fix things before they get out of hand. Some resources of the Attorney General manual. It's not as good as it used to be because it's not updated right now. They're in the process of working on an update, but they don't have a lot of the new notice requirements and things in their manual, but it's still a good resource. And you can always reach out to the DA's office, to Martha, to Andrew. We want to help you. We appreciate your service as board members. We realize that you guys get the heat on a lot of things. And unfortunately, that comes with the territory, but we want to try to help you work through those things so that you can do what you're asked to do as a board member. Here's the contact info. If you have you need anything, feel free to contact Martha or myself, and we'll try to help you out. Any other questions?
Yes.
Yeah.
This is, adjacent to what you're talking about here, but we do our recordings of our minutes, or of the meetings. And then I'm the secretary for the Stagecoach Cab. And when I'm putting together the minutes, technology today has advanced to the point where I can take that recording and have it generate a summary of the meeting that I use for the minutes. Because of my background, I know that there's some, I have concerns about that, about the accuracy of it and so on. So, it's always review that very closely. And I haven't done this yet, but, I'm thinking about using that technology in that way. Do you have concerns with that?
Yeah. So the question, I think everybody probably heard it, but can you use like AI or another tool to help create the minutes? I think that's fine. And I think that's the way things are going for sure. Do I have concerns with it? Yes, because AI, we've all seen how it works. And I think it's, you just, like you were saying, you just have to be careful and review whatever it is, because once those minutes are approved, those are the minutes. So really making sure that the board carefully reviews those and that they meet the requirements is most important. Just because you have AI generated as your starting point, that's not good enough for the board to say those minutes are fine. Still need to review them, clean them up, make sure they meet the requirements and they're accurate. There are some great tools out there. I know we all go to Zoom meetings. A lot of times people are recording the Zoom and you get an email a half hour later with the summary of the meeting. But we've also read those summaries, and some of them we say, hold on a second, that's not exactly what happened. So just be cautious with it. But it is a valuable tool, and I think it will help a lot with minutes, and it'll provide a lot of that substance that you need to include in it. Any other questions? Anybody else using AI for that kind of stuff? Yeah, Charles, let me. Oh, go ahead.
Yeah, posting our minutes. Right after the meeting, our secretary is very good at getting them done, and she sent them down, and then you guys have posted them, but they haven't been approved at the next meeting of our board yet.
Yeah.
We've discussed, should we write draft on those when we send them to you?
Yes.
We've been told now on the agenda, never put draft on it. Because it's not a draft, it's the agenda.
Yeah. Yeah, on the minutes, question is on the minutes, your secretary does the minutes, sends them down to Martha, they get posted, which we want to meet that 30-day requirement, right? And a lot of the boards just don't approve the minutes within 30 days because of timing. It's not going to happen. And so, yeah, put draft on those minutes, they'll be posted. And then when Martha gets the final minutes, she will fix that.
Steve, I have a question. I have two board members that are absent at a meeting. The following meeting, you go to approve those minutes. They are there, but you're missing one member from that meeting. Can the people that were not at the original meeting vote to approve those minutes?
Okay, question is, I understand the question. Yeah, comes up a lot. The question is, you're not at the meeting. You show up at the next meeting. The minutes from the prior meeting are on the agenda. Motion to approve. If you weren't there, can you vote on those minutes? The answer is yes, you can vote on those minutes. Approving the minutes is part of the board action. You don't have to vote, but you're not prohibited from doing so. There's a lot of things that happen. You may have reviewed the meeting. You may have watched the Zoom. You may have done something else after the meeting. You may know what happened. You can read the minutes. Remember, the minutes are just a record of what happened. You don't have to be present to vote to approve those. And so and you'll see that happen a lot with a lot of boards. People weren't there, but they still vote to affirm the minutes because they've had a chance to review them. It reflects their understanding. None of the other board members are objecting. Your staff is recommending approval. We don't view it as a problem for you to vote on that item.
Thank you.
Any other questions? All right, thanks. I think we'll take Andrew, how 5-10 minute break?
Yeah, just a 5-minute break.
5-minute break. Thanks.
Good morning, everyone. My name is Martha Tapia. I'm the administrative assistant to the county manager. I'm also your board liaison. It's good to see so many of you here this morning. Thank you for coming. So these are the topics we're going to cover this morning. Review of open meeting law. Some of it's a little bit of a repeat of what Mr. Wright said in regards to open public meetings, agenda requirements, notice of meeting, cancellation of meeting, meeting minutes, and your letters of transmittal, roles and responsibilities, compliance communication board officers, and role for the CAB member. For open public meetings, CABs are subject to the Nevada open meeting law and as such are responsible for complying with all open meeting law requirements under NRS 241. Please familiarize yourself with the open meeting law manual. Like Mr. Rice said, it's a little bit out of date in the process of being updated, but still has lots of good information. Seek guidance from the county manager's office as necessary. Please reach out if you have any questions. I'm here to help. I don't want any of us to get in trouble for any kind of violations or anything. Just ask. If I don't have an answer, I'll find one. I'm still fairly new to what I do, so I don't have all the answers, but I can definitely help. I'll get someone to help us. It's the responsibility of the CAB members to ensure compliance with all open meeting law provisions. The agenda is the public's notice, and it's not just to organize your meeting. So let's get a meeting agenda. Agenda requirements. The substance of the notice is the agenda and must be posted no later than 9 a.m. 3 working days prior to the meeting. That does not include holidays, so keep an eye out for those holidays. Per NRS 241.020, the agenda must include the following. This is a little bit of repeat of Mr. Wright's information, time, place, location, where the agenda has been posted, the CAB email for the name, and email address for the person from your board that can provide backup material, where public comment can be sent to, that type of stuff. Make sure your statements are clear and concise of all topics to be discussed or considered. You're informing the public that items may be taken out of order, combined for consideration, or delayed or removed at any time. You're going to want to have at least those 2 public comment periods at the beginning, at the end. Make sure you're noting for possible action, for discussion, for presentation, for report only. Topics not properly noticed in the agenda cannot be discussed at a meeting. The agenda must follow this order of business. You're going to call to order. You're going to have your notification. And then you're going to go into your roll call, public participation, review and adoption of the agenda, the body of your meeting, so the approval of the minutes, your comments, reports, and then your public hearing item, your last participation, and your adjournment. Homework. Please review your agenda.
Martha?
Yeah.
Please speak up or hold the microphone. You're such a quiet voice.
Sorry, I feel like I'm yelling, but
No, you're doing great.
There you go.
Can you hear me a little better?
No.
No? Okay. Better now? Okay. So homework, please review your agenda. Something I found helpful, take your agenda, the last 2 slides, just check off one by one, make sure your agendas have all these requirements. Okay, so once your agenda draft is ready, it's going to be reviewed. You're going to check for any missing items, additional items, review your wording, make sure you have for possible action, for report only, for discussion, for presentation only. Check, are your items well written? Are they clear? Are they concise? Do they describe your board's action? You'll want to email the chair of your board before you post the agenda to make sure you get their approval. Next, you'll want to send it to our office, countyclerks@lyon-county.org. The county manager does need to review and approve those. If you have questions about language of your agenda items, please reach out. We're willing to help. There's times where staff will ask you to edit your agenda. Please keep an eye on your email. So we'll write back. Maybe it's an item where you're not understanding what exactly you're trying to do. We'll ask questions. We'll let you know, hey, you need to tweak this, tweak that, add this, take this out. So just keep an eye on your email, please. And then confirm with your presenters that they will be at your meeting. So notice of meeting for cabs. Email the county clerks, again, at least 5 working days prior to your meeting. This allows time for your agenda to be reviewed, any adjustments to be made, and for it to be posted in time that 3 days that we were talking about. Staff will review and post to the websites and respond. That will be your notice of posting. Staff or myself, I'll retain the notice of the open meeting law posting requirements for all the cabs. All the other boards, you'll want to retain that yourselves. The agenda must be saved in your Google Drive documents if you're a cab, and then the other boards you'll want to retain at your principal office. Agenda must be posted at the principal office of the public body and the Lyon County and the state website. Again, no later than 9 a.m., 3 working days before that meeting. Drafting your minutes. Copy and paste your items from your agenda to your meeting template. You can pre-fill in any motions and then edit them at your actual meeting, and then bring your draft with you to your meeting. For your minutes. So the county manager's office will retain minutes for at least 5 years per statute. And then your minutes must include the date, time, and address of the meeting, the members in attendance, whether that was in person or by Zoom or whatever means your board uses. You'll want to make note of your members who are absent. Please make sure to note whether they were excused or unexcused. You'll want to state the substance of all matters proposed or discussed. You'll want to reflect each member's issues or concerns on a matter and reflect each member's vote. Minutes should reflect what happened at the meeting. And then homework again, just review your minutes, making sure you're getting all that information in there. So some more on minutes and audio. Again, this is a little bit of a repeat of what Mr. Rye discussed, but minutes and audio are public records, and draft minutes must be made available for inspection to the public within 30 days after the meeting. If your board doesn't meet every month, the meeting minutes are still required within 30 days. The public body shall approve the minutes of a meeting within 45 days after the meeting or the next meeting of the public body, whichever occurs later. All meetings must be recorded in addition to the written minutes, and this includes workshops. So make sure you're recording and taking minutes of your workshops. Please make sure to send audio as well as your minutes to me after each meeting, and then make sure those get in the Google Drive for those boards that have Google Drive access. If I don't receive or see your audio in your drive, I will be reaching out to bug you for those as well, not just the minutes. So minutes, what you'll need to verify. In these sample minutes, you can see roll call, who was present in person, who was present via Zoom. Your member who was absent, please make sure to note excused or not excused. In the first public participation, Looks like there was a member who spoke up and had some concerns. The agenda was reviewed and adopted. There was the minutes that were reviewed. Item number 9, the possible action to forward a recommendation to the board. That recommendation to the board. And item number 3, public participation. What should we do with this information? A letter of transmittal, right? So a letter of transmittal for public participation, item number 3. Your letters are going to go to one of the 2 boards. You want to make sure you have the date of the meeting, the name of your board, and then which board, either planning or the Board of Commissioners, you're directing this letter to. The agenda item that was on your agenda, the recommended motion or report, any concerns of the board or the public. And then you'll want to make sure you get this forwarded to me and I can direct it to the proper board and make sure it gets on the proper agenda. So the letter of transmittal for agenda item number 9, the zoning map amendment request. Again, the date of your meeting, the name of your board. In this case, it's going to both boards, both the commissioner and the planning commission, the agenda item that was on your board, and then what your board is recommending, either that the board approve it or deny it, and how everyone voted, and then any comments that your board had that you want to pass along to the other boards. Canceling a meeting. So to cancel a meeting before the agenda is posted or after, there's the notice of cancellation on the back counter there. They're also emailed to everyone. To fill this out, submit them. You would submit this in lieu of your agenda. So if you know ahead of time you're not going to have a quorum and you need to cancel, you send me a notice of cancellation in lieu of your agenda. I'll get that posted. The notification goes out to anybody who's signed up on the county website to receive notification for your board, so they know also that the meeting's being canceled. And then there's instructions on that back counter, and they were sent out via email also. And if you have questions or problems getting set up for those notifications, or if any members of your boards need help getting these notifications, just let me know. Happy to help. So to cancel a meeting after it's started, perhaps you didn't have enough members to show up at your meeting the day of whatever reason, and there's no quorum present. So what you would do, you would start the recording of the meeting. You're going to go through the steps on your agenda as you normally would. Once you get to roll call, you'll note the members present, who's absent, and then that the meeting, you'll make note that the meeting's canceled, and that's the end of your meeting. You're going to save your minutes, your recording as normal. Those would get sent to me for posting, the recording for record retention purposes as well. So the administrative functions and processes of your board. The board officers and what they do. The chair is ultimately responsible. However, the officers work together and share the responsibilities to function within the open meeting law. The chair is responsible for retention of all documents, facilitating meetings, review and approval of agendas and letters of transmittal, emailing correspondence, and communicating with the commissioners and the county manager's office. The vice chair is the backup to the chair, and the secretary helps the chair facilitate and monitor open meeting law. The secretary helps the chair to facilitate meetings and monitors open meeting law. Drafts agendas and minutes. The secretary can be delegated record retention tasks, and they can be delegated the responsibility for email and correspondence. So interaction with the county manager's office. We're here to provide administrative assistance, supplies, facilitate the information flow between the commissioners and the public. We monitor and post publication of each board agenda, minutes, and cancellation notice. We retain the minutes, agendas, audios, and minutes. The county manager provides office provides the primary administrative assistance to the CABs, and other county departments will assist and provide information to the CABs on specialized issues. Yes, sorry. Requirements, at least 2-week notification of staff attendance. So if you want somebody, say from planning or from roads to attend one of your meetings, we need at least 2 weeks notice to have a staff member present. Utilize your county email and Google Docs. Email your agenda at least 5 days in advance of the posting requirement. Submit your meeting cancellation notice. Save retention documents and audio monthly. Turn in audio from each meeting on a monthly basis. Turn in your final minutes to be posted after every meeting. Provide draft minutes within 30 days to comply with NRS. So within 30 days, I need those draft minutes, like Mr. Rice said. Once you get your approved minutes, send those to me. I'll replace your draft minutes with the approved minutes, and we're good to go. Correspond with the Board of County Commissioners via letter of transmittal. And then it is best practice to attend the county commissioner meetings and participate when applicable to give advisory board reports. Another reason why the minutes are important. I know I bug you guys a lot about getting those to me. So not just for NRS compliance, but the comptroller's office will audit minutes on a regular basis. Reason for that is the county pays workers' comp fees to all board members present at each county CAB meeting. So to be fiscally responsible, we only want to pay for the members who are actually present at each meeting. So not just to comply with NRS, but for financial purposes, the comptroller's office does need the head count on all your meetings, and prompt posting of those meetings allows them to be able to make that happen to get the accurate payments made. So the Board of County Commissioners, who they are, and their email addresses. So the Board of County Commissioners is the legal governing body of Lyon County. The board consists of 5 members elected from each individual district in the county for a staggered 4-year term. All commissioners can be contacted via email by submitting a letter of transmittal report to the county manager's office. And then as of calendar year 2026, these are your commissioners for each district and their email addresses. Some helpful websites, your agendas, the handbook, the bylaws, minutes, all can be found on the county's website. The NRS. So if you ever wanted to look at the open meeting laws on for boards, the Nevada legislature website has a very user-friendly website where you can go and look those up. And then the open meeting law manual and the AG's website, and that those links are provided here. Any questions? Mandy?
So I have a question on the reports at the BOCC meetings. What should that report entail? Should it just be a general, I mean, I very rarely see CABs, and we don't either give reports at those meetings. Should it just be if there was a decision made for possible action at a meeting? Should it be a general review of what happened at the meeting? What should that report entail? And then I also have a question about the letter of transmittal. If a CAB makes a recommendation, when that item comes up on a BOCC meeting, I never see where the commissioners even state what the recommendation from the board was. So sometimes I know as boards, we kind of wonder if they're even being looked at. And that's kind of just a comment, I guess.
As far as the reports from your board, we've had boards come to meetings and report that they have a special event coming up, invite the public to attend and the commissioners to attend.
So the reports can kind of be whatever, whatever the CAB wants to report, that relates to that board. So if you've got an item that you've heard, you can talk about the decision that was made or the recommendation that was made if you'd like. You can talk about the special events that Martha talked about. I know, Andy, you've talked about events in Stagecoach and things. We put that on the agenda just so that the boards have an option to present. It's not a requirement. But it is there, and I think the Board of County Commissioners likes hearing from the CAB. So.
And Steve, right, the thing I would add too is on your transmittal letters, those are very important to the board. We do get requests from time to time to see if they can continue an item to get those letters or whatever. Just because they don't make a comment, they are provided to the board, and the board does consider those as part of the overall item. So they are important. Want to get those as timely as possible.
Any other questions? Thank you, everybody.
You guys want to take another break, or you want to jump right into it? Yeah. Okay.
So any of the boards that don't involve planning, you're welcome to stay or welcome to leave at this time. It's entirely up to you. But for the citizen advisory boards that do, I would ask that you stay because it's really important.
You think you put that in?
I saw you over there.
Yeah, we intended it though. No, we're here for the fun. Like, you never got out here, that is like, oh, it's crazy.
Sure.
Coordinated as you and Steve. So. All right, can everyone hear me? I'm a little soft spoken as well, so I'll hold the microphone as close to my face without putting any drool on it. So good morning. My name is Gavin Henderson, Lyon County Community Development Director. Today's presentation is just a general overview of a public or planning process and procedures. The quick agenda is we'll go through a couple definitions, master plan, land use designations, zoning, talk a little bit about the public process. I know, for instance, that slide specifically has some small font on it. It's probably even smaller the way we printed out the packets. So if you want a blown up version of that, please let me know. We can get that to you. We'll talk a little bit about voting on action items, findings, which are highly important when we're voting on action items. And we'll go through a couple example entitlements, and then we'll talk a little bit about infrastructure. So some quick definitions. So zoning is the regulatory framework used by local government to divide land into designated districts or zones. Each zone identifies what types of uses are permitted, conditionally permitted, or prohibited, such as residential, commercial, industrial, or agricultural uses. And zoning is the primary tool used to implement land use policy at the parcel level. Second, master plan. This is the definition per NRS 278-150. So it's a long-term comprehensive plan adopted by a planning commission or governing body that serves as a guide for the physical development of the land. It may include elements such as land use, transportation, conservation, housing, public services and facilities, recreation, and safety. Quick to note that these are updated every 10 years. So we're coming up on that. We'll have to have a new master plan in place by the end of the year 2030. Planning to start that process next fiscal year. So look forward to participating in all the CABs during that process because it is heavily involved with public and stakeholder engagement to make sure that plan is comprehensive as possible and fits the community needs. So the master plan is advisory in nature. It serves as a guide to the community at a policy level and to guide future development decisions. It does not by itself regulate what you can or cannot be built on specific property. That falls to zoning, which is regulatory in nature. It is the legal mechanism used to implement the master plan. Zoning establishes what uses are permitted, what densities are allowed, and what development standards must be met for a particular parcel. In simple terms, the master plan sets the direction and the zoning provides the rules to carry out that direction. Understanding this distinction is important as decisions must be evaluated for consistency with both the policy guidance of the master plan and the regulatory framework of the zoning code. And then the picture on the right is just a screenshot from the Lyon County master plan. These are available on the Lyon County website underneath the planning tab. So you can see it breaks it out into commercial, mixed use, suburban residential, parks, public, quasi-public, and each is kind of color coordinated on the maps. So first and foremost, master plan designations are not the same as zoning districts. Again, they do not regulate land directly. Instead, they provide a framework to guide future development in Lyon County. Think of the master plan as the long-term vision for the county. It reflects what the community would like to see over time, how areas may grow and change, but does not replace the zoning or control what can be built today. Because it's a long-range vision, master plan designations are not always consistent with current zoning or even existing development. That's normal, and it reflects how a community plans for future and changes over time. These designations, again, are based on input from the community and elected and appointed officials. And then master plan designations do not remove or change owner entitlements to the properties. So that's important to note as well. Now we'll turn to zoning. So zoning is a set of laws or regulations that govern how properties can be and cannot be used in specific geographic locations. So zoning determines what property owners have rights to do with their property. And then in the case of an inconsistency between the master plan, which is MP, and zoning, the zoning district governs uses and entitlements on the property. Yep. So it's in the box in the bottom right. So in the case of an inconsistency between the master plan and zoning, the zoning district governs uses and entitlements on the property. Correct. So essentially, yes, if there's a conflict, we would revert back to zoning. The zoning controls what a person can or can't do on the property. So we would, in our process, we go to the land use tables, which is chapter 320 underneath title 15. Those tables break it down into the zoning districts, whether they're industrial, residential, commercial. And basically there's a use category on the left side of the table. We've tracked that down, find the applicable use. You scan to the right per the applicable zoning district, and then it either has a C for conditionally permitted, a P for permitted, or there's a dash, which means it's not permitted. And we would use that to control what can or can't be done on the property. The next slide. So the county cannot change the zoning on a property without the property owner's participation or consent. Zoning is tied to property rights, and changes to those rights are subject to legal protections. If zoning were changed in a way that removes or significantly limits a property owner's established rights without due process, it could be considered a taking under the 5th and 14th Amendment of the U.S. Constitution. For that reason, zone changes are typically initiated by the property owner. In limited circumstances, the county can initiate a zone change with the property owner's consent if there is a reason to do so. The proposed zoning must be compatible with the master plan. So if we're going to make changes to that parcel, we revert back to the master plan as far as keeping that consistent with the community needs and that whole process and that document as far as it's been adopted. It is also closely tied, zoning is also closely tied to private property rights, and any changes must be handled in a way that is consistent with both the law and, again, the county's long-term vision and goals. So this is the slide I was talking about. Again, font's relatively small, but really the main important item to notice is again that picture to the right, which summary. So just to walk you through it, it's pretty general on the right. The picture that you may be able to read will walk you through the more complex process. But typically, we get an applicant submittal for a planning related item. Staff has 3 days to issue a completeness review for that application. That means all the documents are there, staff's reviewed it, and at that point in time, that application can move forward through the public hearing process. After that, it's distributed for review to internal departments, so planning, roads, utilities, county engineer. If outside agencies are involved in that process, Nevada Department of Transportation, Nevada Department of Environmental Protections, we also distribute to those agencies as well. After that comment period is over, staff assembles our staff report. After that, we issue the public notices, which go out to property owners within 30 feet of the parcel or 300 property owners, whichever. We're trying to hit that public noticing requirement. So it's 30 property owners within 30 feet, or we have to extend that boundary out to 300, but we need 30 individual property owners there. Planning Commission recommendations. So if depending on the application type, sometimes the Planning Commission is the final decision-making body. Most applications, the Board of County Commissioners is the final decision-making body. Parcel maps are a good example of those, fall in the lap of a Planning Commission as the final decision-making body there. If the Planning Commission makes the final decision, there is a 10-day appeal period for those items. If not, they provide that recommendation to approve or deny the project to the Board of County Commissioners. And after that process, depending on how the decision-making process there at the board level, that appeal period is then 25 days. After that 25 days, staff issues that final action or determination letter to the applicant, and that's just putting a bow on the process. And then the applicant has a final determination there in hand that runs with the property. Voting for an action item. So everyone knows there's 3 ways to vote. You can say yes or no or abstain. If one is voting to approve the item as presented or modified in the motion, you may elect to provide a reason why, but you're not obligated to do so. If you vote no, a reason based on the findings or misrepresentation of the item by the applicant or staff, or a valid rationale must be offered for the record, particularly when staff has recommended approval. And it's not acceptable for your reason to vote no or deny a project is just to say, I don't like it. So we like to say you need to base those on the findings, and we'll touch on the findings later in the presentation as far as a reason to deny or recommend denial of any project at the CAB level. And then abstain from a vote. So one elects to not vote on the item based upon a real or perceived conflict of interest or being ineligible to vote. So this determination of a non-vote cannot be made to avoid a contentious issue or vote. Examples: family business connection to the commissioner, or approving minutes for a meeting when it did not attend, which Steve and also answered that question as well. So findings for recommendation of approval. So findings are a set of list required conditions that must be met in order for a project to receive a recommendation of approval from staff, from the citizen advisory boards, from the planning commission, and ultimately the board uses those findings to make their final decision on applications as well. Findings are specific to the type of entitlement. These are commonly referred to as legal findings. The decision on whether to recommend approval or denial for a project is primarily based on whether the project meets the findings for the specific application type. And again, the Citizen Advisory Board should use these findings to either support the project with mitigation where necessary or when recommending denial. So next, we'll just touch on 3 example entitlement applications. So for instance, this is our zoning map amendment findings. So as you're going and reviewing the zoning map amendment, these A, B, and C are what staff uses to recommend approval or denial for a zoning map amendment. And outlined in blue are some of the main topics. So consistent with policies embodied in the adopted master plan. So again, we're referring to the master plan to make sure everything's consistent there. not to be consistent with adequate public facilities policies contained in this title. So we want to ensure that the zone change wouldn't extend any infrastructure issues there, and then compatible with actual or master plan adjacent uses. So compatibility is a huge one for us. Looking at neighboring properties, what is the current zoning? It is a planning practice not to spot zone properties. So for instance, if you're in an industrial section of the county like Mound House, where everything in there is zoned heavy industrial and someone wants to rezone a property to residential, right? Obviously, we have compatible issues there, just from a use category perspective, but also you would establish an island of residential in a heavy industrial zoning district, which is not a common or acceptable planning practice. So next we'll touch on tentative subdivision maps. So just a brief definition. So a tentative subdivision map is a map made to show the design of a proposed subdivision and the existing conditions in and around it. It also include preliminary infrastructure, water, sewer, storm drainage. There we also see traffic impact studies come forward with tentative subdivision maps. Touch on the CAB responsibilities. So the CAB provides a recommendation to the Board of County Commissioners. And then the Board of County Commissioners may also add conditions to the tentative map prior to approval. Important to note that these conditions must be based on development standards adopted by the county. If not, they can be considered capricious or arbitrary. And then the final outcome. So again, if the zoning is correct, the findings are met, and all the development standards can be met through the conditions placed on the map, the CAB may forward a recommendation or approval to the Board of County Commissioners for the project. If the findings can't be met, then obviously that will inform the recommendation there as well. These are the tentative subdivision map findings. There's a lot of them here listed, but it all comes back to compatibility, land use. Can the infrastructure support it? Do the conditions resolve and mitigate any issues with the project? And if all of those findings are met, then that informs staff's recommendation moving forward in the process as far as approval or denial. Just to touch on, wrap a bow on the tentative subdivision map process. So after a tentative subdivision map is approved, next we get into the final subdivision map phase of the project. That map has to be recorded in order to formally split the larger parcel into smaller parcels. So the individual lots, what we would most likely see as a residential subdivision. Site improvement plans must be submitted currently with the final subdivision map. So we accept both of those applications at the same time. And that's to make sure that those site improvements are matching what's outlined on the final subdivision map. And then once the final subdivision map and site improvement plans have been approved by the county, this is an administrative process. This does not go back to any of the boards for any sort of formal approval. They post the security for the project in an amount of 150% of the engineer's estimate. That engineer's estimates for all the work to be done for that subdivision. So the roads, water, curb gutter, sidewalk, storm drainage, stop signs, street lights, pretty much everything entailed with the project. Or they can elect the county to hold the final subdivision map. So we would not allow the map to record until those improvements are completed and signed off by the county. And then after that process is gone through, the permit is issued and construction commences, and then you'll see bright yellow equipment running around close to your neighborhoods. And then if you have any questions, if there's projects in your area that come to light, we are working on a development map with our IT department, which will be posted on the county webpage hopefully soon. We're working out some technical difficulties with it, but it'd be a good resource in the future to view all the projects in Lyon County. You'll be able to pull them up, see the decision letters, see what the project entails, how many lots are in that phase or part of that subdivision. Is it under construction? Is it in review? And those kind of sort of things. Without that currently, you're more than welcome to contact staff. We also have a planning email, planning@lyon-county.org, where you can forward any questions from the public or the boards that you may have, and I'm more than happy to answer those. The last application we'll talk about is the CUP, which stands for conditional use permit. So if we go back to those land use tables, like I previously mentioned, if you're trying to do a use on the property, you go to those land use tables and you see a C right there, that stands for a conditional use permit. That's a two-part public hearing process. Three, if you count, we'll count the cabs. So it has to go to the cabs, has to go to the planning commission, and then the board of county commissioners is the final decision making there. Usually, and most of our applications start with a round table, and this is just a meeting wherein staff from multiple departments, planning, roads, fire, sometimes building, will review preliminary plans and solicit feedback. And this is just to highlight any issues that the property owner should be aware of before they submit a formal application to community development. After that, staff and we receive an applications. Again, staff distributes for comments, then works with the applicant to make the project appropriate for a conditional approval. The conditions of approval would address matters such as roadway improvements, specific studies, easements, water rights, etc. Staff determines upon the applicant addressing the conditions of approval whether or not the findings for the CUP can be met. So again, us as staff use the findings to make an objective decision. Those findings help remove, the bias of the decision-making process as far as, did you meet these findings? Yes or no? If not, this was the reason why. So the CAB shall review the project, associated conditions, and determine if the findings can be met and forward a recommendation to the Board of County Commissioners. And then on the next slide, this is just the CUP findings. So 15-230-06. You'll see a lot of the findings are similar. So we talk about traffic, we talk about consistency with the master plan, character of the community. Does it incorporate proper mitigations to address adverse effects? And then the big one is number 6. So the use will not be materially detrimental to the public health, safety, and welfare, and will not result in material damage or prejudice to other properties in the vicinity. So this is a question staff gets asked pretty frequently is, why does it seem like staff always recommends approval? So staff says no pretty frequently, and those projects just don't make it to public hearing. So that's part of the roundtable process. So we highlight issues that the property owner wasn't aware of, or maybe there was incompatibility with the master plan, or maybe the zoning doesn't allow what the developer wants to do. So staff says no, or we try to address those issues. And a lot of times, those applications don't come forward. Sometimes they do. It's at that point, it's at the applicant's risk to go through the public hearing process and to see how that shakes out. Companies and developers will rarely file a formal application if they know if staff is going to recommend denial. Again, are they willing to spend the money or take the risk if staff is going to recommend denial as far as those findings not being met? By the time the item has reached the Citizen Advisory Board, Planning Commission, or the Board of County Commissioners, staff has reviewed the project several times with the applicant to make sure that the project meets the findings and development standards, and as condition can be recommended approval. And then we wanted to touch on some example reasons to recommend denial. So staff can't reasonably mitigate impacts with conditions. So typically conditions of approval require pavement of roads, attainment of easements, dedication of water rights in order to meet the findings. If the developer or applicant cannot successfully do that, obviously that would be a reason to recommend denial. Another one is staff may be aware of a pending project in the vicinity that has not been constructed and would be a bad fit. So i.e. a zone change to heavy industrial with an intensive project to follow would not be a good fit next to a planned strip mall or residential development. Another one is staff does not have enough information. So we're missing traffic impact studies or assessments, any sort of the studies related to infrastructure or anything that would not allow us to make an educated decision or recommendation to the board would be a recommendation for denial. And then the last one is the proposal is inconsistent with the master plan, and then the findings can't be justified. Next, we'll get into the infrastructure part of the process. We'll touch a little bit on water and water rights. So water and water rights are regulated by the Nevada Division of Water Resources. They're based on the water available in that specific hydrographic basin. There's different types of water rights. There's groundwater, surface water rights, and then water rights are a property right, much like zoning. So even if Lyon County regulated water rights, the county cannot take away water rights. We can require them to be dedicated on a parcel with a parcel map or a subdivision map, but we can't take away water rights. And then again, the last one again is for every new lot created, water rights must be permanently dedicated or surrendered to either a division of water resources if you're using a well, or to the utility department if you're going to connect into Dayton Utilities. Water and sewer utilities. So projects must have adequate water and wastewater plans to serve the development. The developer is responsible for any costs associated with those improvements. And then we do want to touch on septic tanks because we do get a lot of questions about that as well. So they're only allowed if you're not within 400 feet of an existing sewer line, and that is to the parcel line, not where you're putting the project. Minimum lot size of 1 acre if lot is served by a well, and a minimum lot of ½ acre if served by a community water supply. And this is a big one. This affects all of the county, but more specifically, the area of Silver City. A lot of those lots are less than that ½ acre requirement. Obviously, they don't have a sewer system up there, so it does present some challenges there related to infrastructure. And then roads. So developers are responsible for building all new roads within a subdivision to county standards. After passing inspection for compliance with our road standards, the county will/may accept for maintenance. That maintenance period is a 1-year period. The developer is responsible for any off-site road improvements for which the development would bring below the accepted level of service. So this goes back to our traffic impact studies and why we put such a heavy weight into those studies, because really they show what mitigations should be constructed to alleviate the traffic concerns that come forward with that project. All roads must be built to county standards even if they are to remain private. And then again, after passing final inspections, they get into that 1-year warranty period, and they post a 10% maintenance bond. And then after that 1 year, when that 1-year warranty period comes up, we do another final walk of the project, develop a punch list there. Once they resolve all those punch list items, then we'll bring forward a resolution to the board to accept those roads for dedication and maintenance. And then the last one is storm drainage and development. The amount of runoff created on site and leaving a property must be the same before and after development. This is why we see a lot of detention and retention ponds or basins. Those are used to slow discharges for managed release or infiltration. So allow that groundwater or that rainwater to seep back into the soil. Discharge across property lines, and this is pulled directly from the Lyon County drainage guidelines. So surface drainage from any development area shall not cross any property line except by way of natural water course, major drainage facility, approved drainage system within a public storm drainage easement, or permanent surface drainage easement. And then lastly, again, storm drainage infrastructure and improvements are paid for by the developer and maintained by the HOA currently. That's currently how we do things. So as a new development comes in, the county obviously does not have a storm drainage department or a budget to maintain that infrastructure. So that burden is placed on the HOA as that and the establishment of that, and is informed with the CCNRs in that process, and to make sure that those facilities are being maintained and that they're not presenting an issue to that new community. And with that, I'll take any questions or comments. And then the last slide is a good resource tab. This just takes you to Lyon County Code. You click on the link, it'll take you to the master plan, the development code. Within the development code, there's links to take you to the subdivision map section, conditional use permit section, zoning map amendment section, and then master plan. And then the last one is our development applications under review. So this is on the county webpage. So this is a list of all current applications we received. There's where they're at in the public hearing process. And then on the far right of that page is also projects that have been approved, denied, or the determination letters are listed there on the right-hand column. So it's a good place to keep track of developments as they're kind of going through the process until we have that development map done.
So comparing zoning and conditional use permits and master plans, say a property owner has a property that's zoned in a particular way, and he wants to use the property for a different use. They could apply for a zoning change, right?
Yes.
Or they could apply for a conditional use permit that wouldn't change the underlying zoning, but would allow them to use the property for something other than what it's zoned for. Is that right?
Not entirely. So we again go back to chapter 320 in the land use tables. So the land use tables break it out to where that use is either permitted by right, which would require, in most cases, an administrative design review. So you submit your project to planning, we take a look at it, we review it to code, and then we tell you your project is code compliant, and here's a list of conditions as well. The conditional use permit process, if it's that same property we're talking about, you don't have the option to pick one or the other. If the land use table says it's permitted, it's permitted. If it says it's conditionally permitted, you go through the CUP process. And then if it's not permitted at all, you can't do that on that.
So it's only when it is in the table as conditionally permitted,
That's correct.
then you can go for the conditional use permit to get specific approval for that.
Correct.
All right, thank you. I'd love to get a copy of that presentation.
Absolutely.
And so if you could give us your email and phone number.
I have all the cab emails, and I can forward this presentation specifically to all the cabs. That way you have it on file.
So I have a question on sewers and wells. Stagecoach, we have no sewer system, so we're all on septic tanks. And wells minimum or parcels are minimum 1 acre. So as an acre is 200 feet by 200 feet, we do have the situation where a well on somebody's property is within 100 feet of somebody's septic on the property next door. Is there now something in place that can no longer happen? Because you're basically contaminating your neighbor's well.
That's correct. That's correct. Yeah. So there is wellhead protections for septic systems. We do have a handout in the building department that specifies all the separation distances there, but it is typically 100 feet from. So for instance, if you're doing a new build, you have to take into considerations your neighbor's septic system location, and that'll dictate where you can place your new well on your property.
So if because of the location of surrounding properties with some surrounding wells, you couldn't fit a septic tank in there because you can be contaminating a well, would that be a reason not to go forward with a split or not?
Potentially. The Nevada Department of Environmental Protection does have a variance process that you could apply for, and they would ask for potentially further studies, a site plan, and those kind of things, and they would provide a formal determination. They've also been a resource for those properties that are below that half-acre threshold that are supplied by a community water system, or maybe you're underneath an acre and you don't have a community water system or a sewer system. There is a variance process that you could apply for, and then they would give the formal determination: can or can you not have that septic system or that well there.
Okay, and then I have another question. Temporary use permits. Is that a public process? And
that is an administrative process. So just like an administrative design review or a building permit, that does not have to go through any sort of the public hearing process there.
Can you go over those a little bit about what they are and where? I mean, you know why I'm asking.
Yeah. As far as temporary use permits or just administrative permits?
Temporary use.
So we have a whole section in county code related to temporary use permits. It's pretty, in some areas it's generalized. In some areas it's more specific. Construction yards, for instance, like the one in Stagecoach, if you read through that, it is permitted in any zoning district. So if we're looking at zoning as being an issue, that kind of crosses out that box there. But it walks you through the specific standards related to that use and how it falls within the temporary use permit process. For instance, food trucks, those require a temporary use permit in Lyon County, so you'd have to pull a temporary use permit. It's good for a year. We're working on a process there to make that a little bit more streamlined because it is property specific as far as the temporary use permits. But it is an administrative process. There are standards to meet, same as an administrative design review. There's findings as well there for staff to make an objective decision about. But it is, like I said, it's administrative. We're more than happy to share that information with the public, but it is a process that's also afforded to the applicant as far as that being an administrative process. I don't know if that answers your question. I mean, I could get to more detail and specific application types, but I mean, it's easier to point you to the right direction in code. And then if you have questions there, because it is, like I said, pretty specific as far as the overall process and the uses that are with it that fall underneath temporary use permits. Well, thank you, everyone.
That was our last presentation today. I really appreciate everyone coming to the training. If anybody has any follow-up questions or contact information has been provided, you know how to get a hold of us. But really appreciate the time today. Thank you.